Welcome to Law Minds. Today's topic is general exceptions under Indian Penal Code. In India's legal framework, certain individuals enjoy exemptions from the operation of criminal law, while others benefit from general exceptions that can absolve them from criminal liability. These provisions, enshrined in the Constitution of India and Indian Penal Code, play a crucial role in safeguarding the integrity of public office and ensuring justice is meted out fairly. Chapter 4 of the Indian Penal Code, titled General Exceptions, encompasses sections 76 to 106, which provide a set of circumstances where an individual may be excused from criminal liability. These defenses depend upon the circumstances prevailing at that point of time, mens rea of the person, and the reasonability of action of that accused. What is honest propensity or burden of proof? Now, burden of proof is given under Section 105 of the Indian Evidence Act 1882. The burden of proving that a case falls within the general exceptions lies upon the claimant. In other words, if the accused wishes to rely on general exception to escape liability, they must prove its existence. The prosecution still retains the burden of proof the guilt of the accused beyond reasonable doubt. Now coming to the categories of defenses under IPC. So mainly there are two types of defenses: excusable defenses and justifiable defenses. Defenses where the accused is excused from punishment due to the absence of guilty mind during the commission of an offense. There are five types of defenses under this category. The first one is mistake of fact, which is section 76 and 79. The second one is accident, section 80. Then infancy, section 82 and 83. Fourth one, insanity, section 84. Fifth one, intoxication, section 85. We will be diving deeper into all these categories in the coming slides. Now, coming to each of the excusable defenses. The first one is mistake of fact. Under section 76 of the Indian Penal Code, an act committed by a person due to mistake of fact in good faith believes himself to be obligated by law to perform it, which he is not deemed an offense. Similarly, section 79 provides that no offense is committed when a person believes himself to be justified by law in performing an act. Being bound by law implies that despite the true facts indicating the commission of an offense, the individual, due to a mistake of fact, believes he was legally obliged to act in that manner. Now coming to the cases. The first case is R versus Tolson. Now, in this case, the defendant believed her husband to be dead because he deserted her for 7 years, but in fact he was alive. But without knowing in this fact, she married, and the court charged her against the defendant with bigamy, and she participated in marriage ceremony within 7 years after being deserted by her husband. The court held in cases where exists a bona fide belief supported by reasonable grounds in the spouse's death at the time of contracting the second marriage, such belief constituted a valid and lawful defense to the indictment. Consequently, the court found that the conviction in this case was erroneous and should be overturned. The judgment underscores the importance of considering an individual's genuine and well-founded belief when assessing their culpability in cases of bigamy. Now coming to the next one is the accident and misfortune. Section 80 of the Indian Penal Code provides that no offense is committed if an act is done by accident or misfortune, without any criminal liability or knowledge, while carrying out a lawful act in a lawful manner using lawful means and exercising proper care and precaution. Now, what are the essentials of Act Section 80? The first one, the act must be a mere accident. The second one, the act was not accompanied with any criminal intention or mens rea. Third one is that it should be resulted from a lawful act done lawfully. The fourth one is that it was executed with proper caution and care. In Sukhdev Singh versus State of Delhi, the accused claimed that a murder occurred accidentally while he was engaged in a lawful act. However, the evidence revealed that the accused deliberately used a gun during scuffle, leading to the death of the victim. Consequently, the Supreme Court ruled that this incident did not qualify as an accident, was not covered under Section 80. Now, in another judgment, Girish Saika was a state of Assam. The High Court held that no offence was committed when two brothers accidentally caused their father's death while involved in a fight. The court deemed the case covered by Section 80 as the act was unintentional and occurred during a lawful activity. Coming to the next section, that is Section 81, necessity. Now, the actions which are done, which is prevent to cause harm without any criminal intentions, are deemed not to be an offense. It is based on the principle of choosing lesser evil to avoid greater harm. Now, what are the ingredients of doctrine of necessity? The first one is that the act constituting the offense is known by the accused is to likely cause harm, but it is done without any criminal intent to cause harm. The act must have been done in good faith. It must have been done to prevent or avoid another harm. The harm aimed to be prevented must relate to a person or property. These legal principles under Section 80 and 81 of the IPC aim to distinguish between accidental occurrences and acts committed in good faith, and those undertaken in dire situations to prevent greater harm, ensuring a fair and just legal framework. Now coming to the case. The case is R versus Dudley and Stevens. So when faced with the shortage of food on a lifeboat, two men decided to kill the third one in order to survive. However, the court held that necessity does not justify murder. Now the next one is infancy, which is under section 82 and 83. Now in this, when the children are below 7 years and are those above 7 years but 12 but lacking a sufficient maturity or understanding whether their act is an offense or a crime, are held not criminally liable. In Hira Lal vs. State of Bihar, the court denied the defense under Section 83 to a boy involved in a violent attack, as there is no evidence of this feeble understanding. Conversely, in Krishna Bhagan vs. State of Bihar, a child aged 9 was held liable for theft because evidence showed sufficient maturity and understanding. Now the next one is insanity. Section 84 of the Indian Penal Code provides a defense to individuals who at the time of committing an offense are of unsound mind or are capable to understand the nature of the actions. The defense absolves them from criminal liability due to their mental incapacity. Now coming to the essential ingredients of this defense. The first one is that the accused must be of unsound mind at the time of committing the offense. The unsoundness of mind must be such that the accused is incapable of understanding the consequences of his or her actions. There should be an absence of motive behind the criminal act. Now coming to M. Norton case. Now, in this case, an individual suffering from paranoia due to schizophrenia shot and killed the secretary of the Prime Minister of England. The accused was acquitted on the grounds of insanity. It's important to note that only legal insanity, which results in the loss of reasoning power at the time of an offense, is recognized as a defense under Section 84 as opposed to medical insanity arising from mental illness. Now let's dive deeper into what legal insanity and medical insanity is. So the first one, medical insanity. Medical insanity, often referred to as mental weakness, encompasses a range of mental health conditions that may impair an individual's cognitive and emotional functioning. This umbrella term includes disorders such as anxiety, depression, and other psychiatric conditions that may necessitate medical condition and treatment. However, being medically insane does not necessarily render an individual to be legally insane. Now, legal insanity, on the other hand, involves a distinct set of criteria and consideration within the framework of a legal system. It is not merely a question of mental health, but to a person's legal capacity and responsibility for their actions. Legal insanity is considered defense in criminal law, and it implies that at the time of constituting the offense, the accused was not in a state to understand the nature and consequences of their actions. To benefit from legal insanity, the accused must establish, often through psychiatric or psychological evaluations, that they were not in the control of their reasoning facilities during the commission of the prohibited act. Now coming to the next one, that is intoxication. Section 85 of the Indian Penal Code provides a defense to individuals who commit an offense while intoxicated to the extent that they are not capable of understanding the nature of their actions. This defense applies if the intoxicating substance was administered without the knowledge of consent. Now, this is a really important point because voluntary intoxication does not excuse criminal behavior, as it is established in Chetram versus State. If the intoxication is self-induced, the accused is treated as if they are aware of their risk associated with their actions. In Baste versus State of Pepsu, the appellant was attempted to plead defense under Section 85 after committing murder while intoxicated at a wedding. However, since the intoxication was self-induced, the accused was held liable for the offense. Now the next one is consent. Section 87, 88, and 99 of the Indian Penal Code deals with the defense of consent. Now what is consent? Consent is defined as an agreement to a particular action involving a positive act of assent of mind. Now what are the essentials of consent? The first one is that the act must be done for the benefit of the person who suffers injury. The second one is that the person who suffers harm must consent to the act, which may be expressed or implied. The third one is that the act should be done in good faith without any intention to cause harm or death. Now, Section 90 states that the consent given under fear or misconception of fact is not valid. Consent is not valid in certain circumstances, including fear of injury, misconception, age below 12 years, unsound mind, or intoxication. In Pune Fatima versus Emperor, where the deceased was misled to believe that the accused, a snake charmer, could protect her from a snake bite, the defense of consent was not allowed in this case, but it is made for their benefit. For example, if a doctor communicates a terminal diagnosis to a patient in good faith, causing mental shock and subsequent death, the doctor is not held liable as the communication was made in good faith for the benefit of the patient. The next one is private defense. That is from section 96 to 106 of IPC. Now, this provides that the defense arises when an individual or their property is in imminent danger and they have no access to the state machinery for defense. Section 97 establishes the right of every citizen of India to protect their life, property, as well as the lives and properties of family members, friends, and neighbors. The Section 98 states that private defense can be exercised against any aggressor, whether competent or incompetent, sane or insane, or acting under misconception. However, the right of private defense cannot be exercised in certain circumstances, including if the act is done by a public servant in good faith in the exercise of its duty, if there is sufficient time to report the act to be public authority, if the act is not excessive, or if the act is done by a third person and the authority of a public servant. In R versus Rose, a boy believed his father was harming his mother and was not liable for the action as he honestly believed he was defending his mother. These provisions ensure the individuals have the legal means to defend themselves and others in dangerous situations while also placing limitation to prevent excessive or unjustified use of force. In the case of Baljeet Singh versus State of UP, the accused party, in the defense of their property, assaulted the deceased who trespassed armed with lathis, resulting in the death of the deceased due to 72 injuries. However, the court deemed the defense excessive. Now coming to the next one, that is the private defense of property. Section 103 of the Indian Penal Code deals with the right of private defense of property, which may lead to causing death. Now, in this defense, there are following circumstances in which this can be invoked. The first one is robbery, second one breaking into a house at night, mischief by fire. These provisions aim to safeguard rights to defend themselves from their property of imminent danger, ensuring a balance between the protection and prevention of excessive use of force. Now coming to the conclusion. General exceptions under IPC provide essential legal defenses, ensuring a balance between individual right and societal interests. These exceptions play a crucial role in promoting justice, fairness, and accountability with the legal system of India.